Good afternoon, everyone, and thank you so much for joining us for our first webinar of 2023. Just a few housekeeping items. You must have pre-registered for this webinar in order to get credit, and that would be done through your NYS FDA portal. Please allow 7 to 10 business days for us to get you your CEU certificate and update your portal. If you have questions during this webinar, please type them in the question box. These will be answered at the end of the webinar. Today, I would like to welcome our presenter, Michael Billock. Michael is an attorney at Bond, Schoeneck & King and specializes in employment law. Welcome, Mike.
Well, thanks very much. Good to be here virtually, I suppose, for this webinar. And as you can see from the screen, we have to have a little fun with this. Given the nature of the topic, and so we'll go ahead and we will jump right in. Hold on one sec here. There we go. Okay, so why are we here? We're here because in 2021, going on 2 years ago, then Governor Cuomo signed legislation legalizing the use of recreational marijuana. And so we have this difference between state law and federal law. So yes, marijuana is still illegal under federal law. It is a controlled substance, a Schedule I controlled substance. And we will talk in some more details about the Drug-Free Workplace Act. We sometimes get questions about this. I'm thinking that most of you are probably not federal contractors, subcontractors, but it is possible that you could be so and could be subject to the Drug-Free Workplace Act. So we'll talk about that under federal law. Now, Department of Transportation regulations also precludes the use of marijuana under federal law, and those would apply regardless of contrary state laws. So, but let's talk about this big picture here in New York State. So, I said as of last year, gosh, as of 2 years ago now, this 2023 correction, and it's already middle of January. But as of 2021, people 21 and over, and again, it's 21 and over, not 18 and over, may possess and ingest or smoke marijuana. And they can publicly possess up to 3 ounces of it and 24 ounces of marijuana concentrates. And you see on the screen that there are many ways of, shall we say, delivery vehicles. So you hear about gummies and edibles, that you see those on the right, the very always fashionable marijuana brownies, and in the middle, these vape pens. Now they look more than ever like other things. They look like pens, they look like flash drives. They're very easy for people to conceal in their sleeves and things of that nature. So just be aware that that people can be vaping and smoking marijuana or vaping marijuana. It is very easy to conceal in that regard. So we're talking about the legalization of recreational marijuana. But one thing that hasn't changed, which a lot of employers are unaware of, is medical marijuana. And this started obviously several years ago with the Compassionate Care Act. So under this law, individuals were not allowed to smoke, but did allow for prescriptions of medical marijuana. And regardless of the fact that recreational marijuana is now allowed and is now legal, medical marijuana is still prescribed by a number of doctors. So, what does this mean for you? The answer is that the Compassionate Care Act still applies. So, how does this apply, really? So, if somebody has a prescription for medical marijuana, what the New York State says is that they are considered to be disabled and might be entitled to a reasonable accommodation. Now, again, this is under the New York State law, not the Americans with Disabilities Act, not under federal law, because under federal law, marijuana is a federally controlled substance. So, this last bullet here, which says that you're prohibited from taking an adverse action against an employee, such as firing them, demoting them, etc., who test positive for marijuana if they're certified to use it. Just on a straight up basis of saying, okay, that's it, you tested positive, even though you have a prescription, you're fired. So, what does this mean? It's really no different than if somebody has a prescription for any other narcotic, right? If somebody came to you and said, look, I have a prescription for codeine, right? They have a extremely bad cough. They get that Tylenol with codeine. It might make me tired. Maybe I shouldn't use certain equipment, or maybe I need a shorter shift because I can't work a longer shift because I get so tired from the codeine. Can I get that as an accommodation? You would weigh that. Can we grant this accommodation or not based on the fact this person has to take this medication? You do the same thing if somebody came to you with a prescription for medical marijuana, or if they test positive for marijuana and they have that medical marijuana card saying that they have that prescription. You can't just say, well, we don't allow marijuana use, you're fired. It's no, you have to consider a reasonable accommodation in terms of, well, can they do their job while they are on this prescription? Does the marijuana really affect their job duties? If it doesn't, they don't really need an accommodation. If it does affect their job duties, well, then we do more of this. The legalese is called the interactive process of, is there a way for them to still do their job duties while taking this prescription? Maybe they could take their prescription in the morning. Maybe they could take it at night. Maybe there's a different shift that they could do, or as long as you don't have to change the essential functions of their position, but as long as they can do the essential functions, maybe there's some things that they can't do when they're taking a prescription for marijuana. But those are all the types of things that you have to get into with employees when they test positive and have a prescription, or come to you about the fact they have a prescription. It is that interactive process of talking with employees about an accommodation that might work. So, okay, that's prescription marijuana. Now let's get into the recreational marijuana. So what does this new legalization do? Well, there's this little known, maybe more known provision of the New York State labor law, which Section 201D, which for years has protected employees' rights to engage in certain recreational activities. So without being terminated, disciplined, or anything from the employer. So it basically says that employees can legally use consumable products, engage in those recreational activities without retribution from their employer. So in the past, this has meant, hey, just because you find out an employee smokes cigarettes outside of work, just because you find out an employee has alcohol or drinks alcohol outside of work, you can't terminate an employee based on that, right? So as I mentioned, this is kind of a little known, little used provision in the New York State labor law, which the New York State legislature said, this is the perfect way to insert this provision about the legalization of recreational marijuana. So what they did is they said that individuals' legal recreational activities, including cannabis, in accordance with state law, outside of work hours, off of your premises, and without use of your equipment or property, is protected by Section 201D. So just because somebody uses marijuana in accordance with the law and in accordance with all these additional provisions that we'll talk about, you can't discipline an employee for doing that. You can't refuse to hire somebody for doing that, and you cannot terminate an employee because they do that. Now, the language of the law had all these kind of additional caveats and provisions. So it is important to know that just because, an employee who smokes marijuana outside of work, off your premises, outside of working hours, okay, it's not an issue. But if they do it during working hours, if they do it on your premises, or if they do it with your equipment or, somehow or other property, I don't know what they could try to turn into a bong, or maybe they use some office paper to roll something. Who knows? But if they do that, they lose that protection, and you can take a disciplinary action against them. You can fire them for doing so. So let's say that an employee is using marijuana and before work, right? It's outside of working hours. They did it before, they're not on your premises, and they come to work, and you can tell that they have marijuana in their system. And we'll talk about how you might be able to tell that shortly. Now, let's say, so somebody's coming to work impaired, right? And think about it, it's not much different. It's somewhat different than an employee who drinks before work and they come in and you can smell alcohol in their breath. Now, if an employee comes in and you smell alcohol in their breath, the difference really is that you can send the employee for alcohol testing, and the lab can say, they've got 0.02 in their system, they've got 0.08 in their system, they've got 0.1 in their system, and above X amount they're impaired, right? Above, and you don't want them to have any impairment. You don't want them to have anything, 0.02 or above. We don't have that yet for marijuana. If any of you are so inclined and have that chemistry degree and want to develop that, you'll make a lot of money, because we don't have that yet. All we really have is the test of whether they're positive or not, and there's not really a correlation in terms of how much THC is in a person's system to how impaired they are, right? Somebody could smoke marijuana a week ago and pop positive, and somebody could smoke marijuana a few hours ago and pop positive, and we can't really tell when they're impaired and when they're not. So what New York State has done and said, well, okay, if somebody is under the influence of marijuana, you can take action against them if they are impaired. How do you tell that they're impaired? You can't do a blood test. They have to show specific, here's the magic legal language, specific articulable symptoms that affect the performance of their duties or that interfere with your obligation to provide a safe and healthy workplace. Okay, so it's really, A, they have to have specific articulable symptoms, and B, those symptoms have to either interfere with their performance or interfere with your obligation to provide a safe and healthy workplace. Now, if there is some other statute, the New York State regulation, federal, then you would have to comply with that. And you can take an adverse action against an employee if the compliance with the new section would require you to be in violation of some other federal law or result in the loss of some other federal contract or funding. Again, I would anticipate the vast majority, if not all of you, are probably not federal contractors, but if that is an issue, or if you receive federal grants, obviously we'll talk a little bit about that, and if you have questions at the end, we can answer those questions as well. So, okay, so we've got federal law and we've got state law. And again, under federal law, marijuana is illegal. And so New York State says, no, marijuana is legal. So what do we do here? Well, courts generally don't like to overturn laws when they don't have to do so. They try to read different laws and different provisions of the same law so that they are not in conflict with each other. And because the federal law that makes marijuana a crime to possess doesn't discuss employment, New York courts have said, well, this provision in New York State labor law is really an employment provision. It's not about the criminal use of marijuana, so it's not really an issue. The fact that marijuana is illegal federally doesn't really affect the New York State law, which says that you can't take an action against an employee for using marijuana unless it satisfies these particular elements of New York 201D. What about OSHA's general duty clause? It requires you to have a workplace that's free from recognized hazards that could cause death or serious injury. Well, again, courts have said there's not really an actual conflict with that. that you can still have a safe workplace with people smoking marijuana, well, not smoking marijuana, but under the influence of marijuana, and so there's not actually a conflict. So if you are a federal contractor or you receive any federal money, you are subject to the Drug-Free Workplace Act. And so a lot of employers say, well, we can prohibit marijuana on that basis. Not exactly. The Drug-Free Workplace Act is kind of toothless. All it requires is for federal contractors and grantees to have a drug-free workplace policy and have an awareness program. And that's it. So anybody that is receiving federal monies, federal grants, and is subject to this act, all they have to do is just say, well, you can't manufacture, distribute, or use marijuana here. If you are, you have to ensure that employees notify you within 5 days if they're convicted of violating a drug statute for conduct in the workplace. If an employee is arrested or convicted of marijuana, possession or sale or something, or even cocaine or something, much stronger than marijuana, shall we say, off premises, the Drug-Free Workplace Act doesn't require an employee to notify you of that. It's only if it's conduct occurring in the workplace. And all you have to really do is educate employees on the dangers of drug abuse in the workplace, in your counseling, and that any other resources you have available. That's it. So what the Drug-Free Workplace Act does not require of federal contractors is to perform drug testing of applicants or of employees, or terminate somebody who tests positive for drugs. So if you have a federal contract, unless that contract has specific prohibitions on employee marijuana use, it's you can't use it as a shield. You can't say, well, we'll terminate employees based on their marijuana use or that they tested positive. You're not going to be able to rely on the fact you're a federal contractor. So, all right. So Austin Powers is asking Basil, state's saying groovy, the feds are saying no dice. What does it all mean? So this is what it means. Currently, and in the recent past, a lot of employers have, different tests for applicants and employee: pre-employment, reasonable suspicion, and post-accident. However, as we mentioned before, you can have marijuana this morning, you can have marijuana, a month ago, and it's still positive. So just because it's a positive test, it doesn't necessarily mean somebody is impaired under the law. They have to have those specific articulable symptoms. So when can you drug test? Well, you can drug test for reasonable suspicion, and we'll talk about that. Post-accident, it used to be, hey, if somebody was, let's say that they are driving a car for work and they're in an accident, and hey, it doesn't matter, we're going to test them, they were in an accident. Now the answer is no. You can only do it if there is some other reason other than the accident that there is reason to believe that the person was impaired. Now, if somebody was broadsided going through an intersection, they had a green light, and the car that broadside them is going through a red light, there's no reason to believe that their judgment was impaired. If they blew a stop sign, they blew a red light, hey, there's some evidence that their judgment could have been impaired, and you can test them. So it depends again, do you have that reasonable suspicion? But the big thing is that pre-employment tests now are verboten under this new provision of New York state law. New York State Department of Labor is taking the position that unless there's a possible violation of 201D, you can't drug test. Well, in order to have a violation of 201D, you have to have impairment that affects an employee's job performance or safety on the job. But you're testing an applicant. They're not on the job. It's not affecting their job performance yet. It's not for affecting, hey, they might be impaired today. You test them today. They're not working till tomorrow. They wouldn't necessarily be impaired tomorrow. So New York State Department of Labor says unless there is some sort of a federal law, you're under a federal obligation, a contract, a regulation separate from just generally being an employer, unless there's some federal requirement that requires it, you do not test applicants for marijuana. So I understand that a number of employers for applicants will have a panel, drug test panel, and marijuana is on that panel, generally speaking, employers have had very good luck talking with the lab saying, hey, we've got the panel test, please take marijuana off the panel. Or if it's too difficult to do so, you still test for marijuana, don't send us the results, we don't want to know it. So one of those two options are the best way to go when you're talking about applicant testing. So we've been talking about impairment and without actually saying what it is, right? So they have to have those specific articulable symptoms. Amazingly, New York has not set forth examples of what those symptoms are. What they have done is said what it isn't. Just because somebody comes in to work smelling like they were sprayed by a skunk 2 minutes before walking into work is not enough that the person has symptoms of possible impairment. They have to have other specific articulable symptoms. We've looked to Illinois, which lists a number of symptoms. They've got a good number of symptoms, and really, when you think about it, we are looking for objective, right? That word of articulable. When you're writing this down, when your supervisor or manager is writing this down, we don't want somebody to write down looked high, acted strange, things of that nature that when you are justifying this decision to a court or an agency, sounds subjective, right? So, well, what does looking high mean? Acting high mean? What does acting strangely mean? We want slurring speech, spoke slowly, used incorrect words, stared at the wall for 5 minutes and giggled, right? Those are all objective things that to describe what actually happened, as opposed to sort of a subjective and vague description. And when we talk about carelessness that results in an injury, as opposed to acting careless, it was walked into a wall, walked into a coworker. Physical dexterity, walk slowly, tend to stumble, things of that nature. So you can look at this list of symptoms and say, okay, hey, again, red eyes, difficulty focusing, it took much longer to explain things, or explain things very poorly, unable to, respond to simple statements or commands, things of that nature. So all those things are helpful. And then, of course, we do have the one symptom of munchies. I don't know if New York State would accept empty bags of Doritos as being a specific articulable symptom, but you never know. So we have seen that positive employee drug tests have gone up an incredible amount within the past year. And and for marijuana themselves, positive tests are up 8.3%. Just in the past year, 50% increase over the past 5 years. So a lot more employees are testing positive, and applicants testing positive for marijuana and other drugs in their system. Now, I've mentioned about pre-employment screening and testing. What about background checks? Well, the law here is New York State Corrections Law 23A. It's also incorporated in the New York State Human Rights Law. So generally speaking, this law prohibits you from saying, we don't hire people with convictions. You cannot do that. You also cannot say, oh, you had an arrest, that arrest was, the charge was dismissed, we're not going to hire you because of that. You can't do that either. If a charge was dismissed, you can't refuse to hire somebody based on that, and you can't just have a blanket prohibition saying we're not going to hire people with convictions. What you can do is not hire somebody for employment if there is a direct relationship between the conviction and the employment. So if there is a concern about safety of people, whether it's the people that the employee would come into contact to, employees, the general public, and the person has a conviction for assault, hey, we're not going to hire that person. If it's something having to do with property, and concern about property. They have a conviction for robbery, for burglary, for something in that regard, and they're going to be around valuable items. You don't have to hire them. If there is some other relationship, right, then let's say you're hiring somebody to be a driver and they have a DUI, you don't have to hire them. Otherwise, you would have to hire them. So if you're hiring somebody to do a different job, you're hiring somebody to be a mortician and they have a DUI in their record, that doesn't necessarily have any relationship, with the job that you're hiring them for. And you would have to go through all these other factors. How long has it been since the conviction? How serious was it? How old were they? So on and so forth, before you would be able to say, we're not going to hire you based on that. Well, a positive marijuana test is no longer disqualifying, and a past marijuana conviction is now generally not disqualifying. And on top of that, New York State is in the process of purging past marijuana convictions. So you may not even see any previous marijuana conviction if you do a background check on an employee. But if you do, just be aware, hey, just because they were convicted of marijuana in the past, it's likely New York State is going to say there is no relationship between that and the job that they are applying for. To the extent that any of you may have a union, which is unlikely, it's certainly not clear of what the effect might be of testing in the workplace with collective bargaining agreements. We're still kind of seeing what that impact might be. Okay, so now we have some tips for you. You can see a very large tip here on the screen. I think that won some sort of world records in Canada, believe it or not, a few years ago. So first of all, you've got your drug testing policies and policies about the use of drugs, at work and things of that nature. Well, go ahead and take a look at what policies you have. You may want to consider having separate policy about medical marijuana versus recreational marijuana, because they do have two different standards. And you may need to have different policies for different types of employees that you have. Just something that you may want to consider. But any policy that you have has to be consistent with this new law. You can prohibit marijuana use or possession on site, or use with your equipment somehow, or on working time. You can prohibit employees from coming to work impaired due to marijuana. And again, review your testing requirements if you are going to do it. If you do have drug testing pre-employment, you shouldn't be testing for marijuana. To the extent you have supervisors or managers, they need to be trained to collect that objective, descriptive evidence of impairment, right? The physical signs. Don't say, as I mentioned before, don't say they're acting strangely or paranoid or disoriented. The employee twirled around in a circle twice in the space of 30 seconds because they were seemed unfamiliar where they were at, even though they worked here for 5 years, right? That's a lot more descriptive term in terms of something that could happen with employees who's high on marijuana. And again, it's not just enough to say employees working slow or can't focus. Explain why. So here, I have a question for you, kind of a case study, where we've got George. And George's employer is reviewing security footage from the parking lot. Notice that there's video of George smoking marijuana in his car. And he admits to the marijuana usage, but says, well, I was in my car. I was not on the clock. So there's nothing that you can do. And the question is this accurate? And we get to my favorite two words in law. It depends. Because there are these different things in Section 201B, which would allow you to take some action. 201D. Question 1, is it during working hours, right? George says, well, I was off the clock. Well, when exactly was this off the clock? Was it before, the start of work was at 9 o'clock and it was at 8:30? Okay, yeah, it was off the clock. So we have to move on to the next question. But if it was during a break, if it was during lunch hour, guess what? New York State actually says that is during working hours, right? If your working hours are 9 to 5, 9 to 6, whatever, with some breaks or lunch break, and he was there in his car during a lunch break, it's during working hours. Then the answer is yes, you can take an action against George. But let's say it's not during working hours. Let's say it was before working hours started. Well, do you own the parking lot? Is that part of your premises, right? Again, the answer is yes. It's on your premises. You're done. You can take an action against them because 201D allows you to take an action against somebody who is using marijuana on your premises. If the answer is no, let's say he was outside at the curb, in the street, something like that, and the security camera footage picked it up. Okay, we've got to move on to the next question. Is he displaying specific articulable symptoms? He comes in, if he's just smelling of marijuana, nothing else. He is the very model of a modern major general, and he can sing the entire song with perfect alliteration. Not that you should make him do so. Well, he doesn't have any symptoms, so he wouldn't necessarily be impaired. He'd probably be upset that he bought some product that was not very strong, but hey, he's not impaired. He could do work just fine, and you can't take an action against him. Whereas if he was impaired, if he's acting strangely, that's not enough. We have to go to questions 4 and 5, right? Is he is his job performance affected, or does his job have any safety implications? So yes, in terms of New York State has said somebody can be high as a kite, but as long as it doesn't affect their job performance and it doesn't affect safety, they can be at work high as a kite, at least according to New York State law. So you could have a custodian who is high as a kite as long as they're doing their job and cleaning things and emptying trash and doing well. There's literally nothing you can do about it. If the custodian is mopping the same section of the floor for a half an hour while singing a Grateful Dead tune, different answer. It seems to be affecting their job performance. So you do have to have the symptoms along with either safety implication or job performance. So we have gotten some guidance from New York State Department of Labor, not a lot, but we've gotten some. Hey, what if we've previously terminated somebody for marijuana use? What if they apply back to work? Do we have to rehire them? And the answer is no, you don't have to, because it was illegal at the time, and they violated the law at the time, and they violated your policy at the time. You don't have to necessarily rehire them. Let's say you've got somebody, hey, we need you to be on call this weekend. Can I prohibit them from using marijuana? The answer is yeah, right? You can say, listen, you're on call this weekend. It can't have you drinking. You need to be able to drive in. You can also say you can't smoke marijuana or use marijuana because we might need you to come in this weekend. Well, what if they just bring marijuana to the workplace? Well, one of those provisions in 201D said you can prohibit employees having marijuana, possessing marijuana in your workplace. So if you have that in your policy, an employee does so, you can discipline an employee for it, unless it's an employee that has marijuana due to a prescription, and they have it pursuant to their prescription as part of your accommodation. To the extent, probably you don't have many remote employees, but to the extent you do have any employees who work remotely, the same provisions, if an employee's on a Zoom call and they're laughing to themselves and you can hear fish playing in the background, okay, you could take an action against them because it's affecting their job performance. They're not doing their job on the Zoom call. But you can't say you're not allowed to have marijuana in your house because your house is where you work. It's still their house, even though it is a remote office for them. Now, one interesting provision is that excuse me, I can't talk today. Who do these provisions not apply to, right? And this is an employment law, so it does not apply to the extent that you have. If any of you are nonprofits, if you have volunteers, it doesn't apply to them. If you contract out to somebody, it doesn't apply to them because they're not employees. Also, it does not apply to employees that you have who are under the age of 21 because they cannot use marijuana legally. If you have somebody who is 18, 19, 20 and they test positive for marijuana, you can test them for pre-employment for marijuana if you'd like to do so. And you can fire them if they test positive because they would not be using marijuana legally. So that is all I have in terms of the presentation. I know I tend to speak quickly, and it's something my clients like, right? Because this way I speak quickly. I don't take a lot of time, but it also allows a good amount of time for questions. And yeah, I'll leave my contact information up on the screen here. You got my email address. And with that, I think I know Kelly has any questions that may have come in, and open it up for that.
Thank you so much, Michael. So if anyone has any questions, please type them in the question box on the right-hand side of your screen. I'll give a few minutes for everyone to complete their thoughts. I know sometimes you're feverishly typing in the questions and don't get them all put in. So we'll give a little bit of a break while we wait for some questions. Okay, we do have a comment. We have a comment that the information and the presentation was wonderful, and they're very appreciative of that.
Well, thank you very much. I will say this is a relatively, I mean, I've been following this legal aspect over a course of a couple of years, but it is a very new thing for me. The joke about the skunk, when I met my wife and the first time I smelled marijuana, I did think that there was a skunk nearby, and she looked at me like I had 3 heads and said, "Are you serious right now?" And I'm like, "Yeah." And oh, yeah, I guess I had a sheltered upbringing. I went to the Naval Academy. It's, you know, marijuana use was not something you could do, shall we say? And but it's been interesting learning about this topic.
All right, so we do have a question. What would the law state okay, so what about an employee that has a company car, but is technically on a day off? What could be the policy there?
So you can prohibit an employee from using marijuana with any of the company's equipment, and that would include the company car. So you could have a policy that says you cannot use marijuana, have marijuana, or be under the influence of marijuana while you are driving a company vehicle, regardless of the hour. Right? We're giving you this car. Doesn't matter if it's outside of working time. We don't want you to be, you know, under the influence of marijuana while you're driving it. So, very good question.
All right. If you're applying for a job, does an applicant have to disclose marijuana use if asked?
So I'll sort of answer that with a question or with a comment of saying that there's no real reason to ask them about it. And frankly, I would advise against asking them about it, because really you get into that issue of, if they say no, okay, you know, okay. If they say yes, what are you going to do about it? And you can't really do anything about it. So I would simply recommend not asking them if they use marijuana.
Do you expect the state to, hang on, keep stopping. Go back up to the top. Do you expect the state to create a legal limit for marijuana like they do for alcohol?
It would be terrific if they did. We just don't have that technology yet, really. We're looking to, you know, once that technology is developed, that would be a terrific thing. But we currently do not have that. So it's something where, I mean, state police have been advised that it's not a same thing with the smell. It's not enough that somebody smells like marijuana if they've been driving when you pull them over. You have to have more to show that they were driving under the influence of marijuana.
If you see an employee acting in one of the mannerisms that you mentioned, can you ask the employee if they recently smoked or ate an edible?
Absolutely. If you have that reasonable suspicion, right? They've got those symptoms. You can ask them, are you under the influence of anything? Have you recently smoked or ingested marijuana? They may say no. Frankly, they may say yes. If they say no and you don't believe them, you can send them for a drug test. I think not in this. We didn't have a case study in this one, but a case study where the person says, no, the reason I'm acting like this is, I have sleep apnea. I'm not getting great sleep. Well, if you can disbelieve their explanation and say, well, we're going to send you for a drug test, as long as you have that reasonable suspicion. And what you really want to have to back up that reasonable suspicion is that documentation of what you observed, those symptoms that you observed.
What responsibility does an employer have if an employee who you feel is impaired leaves the work premises in their own car, and gets into an accident?
Very good question. And so generally speaking, when we feel that somebody is impaired and needs to be tested, we recommend that somebody take them to go be tested, right? It's not, oh, hey, you're drunk as a skunk, go home, get out of here. It's well, we need to make sure that the person gets home safely, or if it's we want them to be tested, that they get to the testing facility safely and have the testing done.
What about the discovery of paraphernalia, pipes, paper, etc.?
Yeah, if you discover paraphernalia in at work, that's enough, right? It's marijuana paraphernalia, and you can say we prohibit marijuana in any equipment used to smoke marijuana or ingest marijuana at work. And so if you discover that at work, you can take an action against an employee for that.
And then this is kind of a question. I tend to think of marijuana as smoking, but what about other consumables like edibles? And they believe that they are, if you believe they're high just on the edibles? Is that still the same?
Yeah, absolutely. It doesn't matter how they took the marijuana, smoking, ingested, vaping, as long as they are, as long as they have those symptoms and you can justify, you can show you've got the documentation that they have those symptoms and it's affecting their work performance, you can take an action against the employee.
Should I allow an employee who is using medical marijuana to perform an embalming procedure at my funeral home?
That is a good question. It really comes down to whether they can embalm properly while taking that prescription. And that is something where if they test positive, or if they come to you and say, listen, I have a prescription for medical marijuana, you would want to have them go to their doctor and with a job description that shows, describes, what it is this person needs to do. And you would want to get medical documentation from the doctor that says, are they able to do this while they take their prescription? And are there any accommodations that they need in order to be able to do this, taking their prescription, right? And the doctor would come back and say, nope, they really can't do this while they have a very strong prescription. I don't see them any way that they could do this while they're on a prescription. The doctor could say, well, they only take this at night and it helps them sleep due to chronic pain or something like that. By the morning, they're okay and they can do this, or some other accommodation that would allow them to do that while they are taking that prescription. So it really depends. You would want to get that you would want to request that documentation and get that documentation from the employee's medical provider.
If that person, let's say the doctor clears them and they cut their wrist using a scalpel, would the employer be responsible?
No, you would not be responsible. Obviously, the employee would file for workers' compensation because it was an injury, so it would be under workers' compensation. But for anything else beyond workers' compensation, the employee couldn't sue you or anything else. You were relying on medical documentation. And going forward from that, it was, well, you know, the doctor was wrong. This person cut themselves, and we're not going to allow them to continue to, you know, to do this work while taking this medication.
In the funeral business, a lot of employees, part of their compensation is they get to live above the funeral home for free. What if the employee is residing above the funeral home in their apartment? Is that considered company property, or do they get their own privacy and can do what they'd like in that apartment?
That is considered company property. So you own it. You have the ability to say, we do not allow X in this place. So, right, the employee could have a concealed carry permit, right? It's perfectly legal to have a pistol with a concealed carry permit, but it's your property, and you can, as a condition of somebody coming on your property, say, no, we don't allow guns. And you can, as a condition of somebody coming on or living on your property, say, no, we don't allow marijuana. So you do not have to allow that for an employee that's living on the premises.
Considering there's no bright line test or legal limit standard, is an employee protected for conducting or accusing an employee of being high and taking disciplinary action?
So is an employee protected from kind of believing that they're accusing another employee of being high?
Yeah, like saying there's no legal limit out there, you know, what there would be for alcohol. So is
Right.
an employee protected if they ask or, you know, taking disciplinary action for someone that's being deemed super high or unable to do their job?
Again, just so long as there's that reasonable suspicion, and if somebody is super high, as you say, there really would be. There shouldn't be repercussion against somebody who, in good faith, is like, no, this person is acting strangely. I think that they're under the influence. There shouldn't be any repercussions for that.
All right, great. Well, at this time, there are no other questions. So, Michael, thank you so much for your time today and for this informative session. We really appreciate it.
You are very welcome.
Thank you. And I'll just remind everyone, please allow 5 to 7 business days for your CEU to appear on your portal. If you have any questions, feel free to reach out to Michael or us here at the office, and we can connect you if we can't answer your questions. I hope everyone has a great afternoon and Happy New Year.